Hello, my name's Amanda Charlton and I'm an Ombudsman with the Legal Ombudsman. Here at this organisation we seek to resolve service complaints between consumers and their legal service providers, such as solicitors, barristers, licensed conveyancers. We look at cases on a case-by-case basis and seek to resolve them in a fair and impartial manner without taking sides with either party. To help us resolve those complaints, we will ask each of the parties for evidence to support the complaints that they have raised, take into account any comments they have, before deciding whether or not the service provided was reasonable. When we decide on reasonable service, we take into account a number of factors, such as the firm's terms and conditions, what's accepted practice within the profession, service level agreements, and any other factors such as promises and assurances that have been made by the firm when starting the retainer. We will keep parties informed as we go through the investigation and share our findings with them. Today I'll be talking about personal injury cases and the types of complaint we see in relation to this area of law. In 2017 we saw approximately 6,000 cases for investigation across all areas. 15% of those related to personal injury litigation. General areas of complaint are delay, communication, cost information and excessive fees. However, there are some specific issues that relate solely to personal injury cases. The most common types of complaint that we see in relation to personal injury cases are in relation to delay and failure to progress the case, poor communication and updates, cost information both at the start and during the course of the retainer, and concerns about the amount of fees that are payable at the end of the case. And then specifically we see issues in relation to the assessment of the prospects of success, both at the start and then changes during the course of the retainer, and issues with the medical evidence that's been obtained by the firm. In a recent case study, we received a complaint from a consumer about the firm's assessment of the prospects of his case, both at the start of the retainer and then as the case progressed and circumstances changed. He said that the firm had originally told him that his case would have a 60% chance of success, and he was really disappointed when further evidence came to light and the firm changed their view. As a reasonable service, we would expect a firm to communicate all changes to the assessment of a case in a timely manner and as soon as possible after new evidence came to light, explaining clearly to their client why they have changed their view and what the impact will be for him in that case. By way of evidence, we would look for attendance notes, correspondence, and further discussions with the client so he fully understood what had happened and where it had gone wrong. In this particular case, we found that the firm's services were being reasonable because they'd done all of that work. However, in other cases that I've seen, communication of changes of prospects of success can be left until really late in the day, such as shortly before a final hearing or an assessment of the case, which means that the client is left with very little opportunity to seek alternative advice or seek a second opinion. When investigating these types of complaints, we will ask both parties to provide evidence, such as attendance notes, letters, emails, correspondence, so we can say what information the firm have provided to a client during the course of the retainer. For example, when looking at concerns about a medical report, we would expect a firm to explain to a client before they obtain a medical report or go to a medical examination what can be expected during the examination and how they will deal with the report when it comes in. Once the report's been obtained, we would expect a firm to send a copy of that report to the client to enable them to confirm whether or not they're happy with the content. We would also expect the firm to explain that they can only ask an expert to change the factual parts of a report or to comment on factual changes. They can't get them to change their opinion or prognosis as to a client's condition. In a recent case study I've dealt with, a client complained that they were unhappy with the prognosis in the report. The firm raised those concerns with the expert, and the expert wrote back saying that he'd considered the comments made, but his prognosis remained unchanged. When that case came to us, we were then able to report back to the client that the firm's service had been reasonable, because this is what we would expect to see in practice, and the firm had done all that they could be reasonably expected to do in those circumstances. What the firm couldn't do was tell the expert to change his opinion in that case. Where we've investigated a case and we found that there has been a failing in the firm's service, then we would look to put the consumer back into the position they would have been, but for the failing in that service. We can look at detriment, whether the complainant has been caused upset, inconvenience, or has incurred additional out-of-pocket expenses. For example, if there's evidence on file that the consumer has had to chase the firm on a number of occasions, they've had to make repeated calls, they've sent a number of emails, or even had to come into the firm on more than one occasion to put the matter right, we would look to compensate the consumer for that. We can also look at financial loss. So for example, where there's been a failure to instruct an expert correctly, and the consumer's had to pay for a second report or incurred additional expense, we would look for evidence of that by way of invoices and cost information, and we could seek to refund those. In relation to cost information, if we find that there's been poor cost information on the part of the firm, then we can either direct that all or part of the fees are refunded. To enable firms to minimise complaints in this area, we would recommend that you communicate, clear communication with the client at all times throughout the course of the retainer, and to keep those records on file. So good emails, telephone notes, and any key advice to be followed up by letter. And then to have a really good complaints handling process in place, so any expression of dissatisfaction is dealt with promptly. I hope you found this information useful. Further information and fact sheets are available on our website. Thank you for watching, and goodbye.